All right, hello. That took a moment, but welcome. We are live. I'm going to give it a minute or so to allow anyone who would like to come in to get on into the room. You'll have to pardon my green screen issues. That's the reason that I'm a few minutes behind. I don't know, something strange is going on with my green screen today. But anywho, I'm going to go ahead and post a little comment in the chat just to say hello to everyone and also to verify that the chat is actually working. This is my first time using StreamYard by myself, of course, not just as a guest. So I want to make sure that everything is functional. All righty, perfect. Okay. So everyone should be able to see my comment in the chat, which means you should be able to comment as well. All right, so let's get started. Welcome. So we will be discussing the Tulsa Real Estate Fund, the paperwork or the contract that all of the investors have to sign. By the way, the Tulsa Real Estate Fund calls their investors members. So that's just an aside. As we go through the paperwork, you will often see references to members must do such and such, or members must be advised of such and such. And I want you to be aware that members are the term that's being used for, members is the term that is being used for investors, okay? So I'm going to share my screen and we are going to dive right in. I want to put my phone on silent to make sure that we don't have any interruptions. All righty. And let me go ahead and enter the chat as well to make sure that we are streaming and functional. Yes, we are. Okay, so share screen. Okay, so you should be able to see my screen. Wonderful. Now we are in Safari. You should be able to see. Actually, I don't think you can see what I'm looking at here. Let's see. One moment. Okay, there we go. Now you can see everything. Perfect. So the first thing we are going to look at is the Tulsa Real Estate Fund's operating agreement. So for those of you who might be unfamiliar with SEC offerings, and by the way, I live in an urban area, so you have to pardon if you hear anything crazy going on outside. So for those of you who may be unfamiliar with SEC offerings, IPOs, and things of that nature and how it works, the way that it works is before you can offer something as an IPO, so before anyone in the public can be allowed to purchase any interest, to purchase any stock, anything of that nature, right? You have to file with the SEC for you to be publicly offered. So this document that we are looking at here is what was filed by the Tulsa Real Estate Fund to allow them to be able to register with the SEC for public investors to purchase from them interest in the Tulsa Real Estate Fund. So what does that mean? Well, what that means is all of their members and all of their investors, as a part of agreeing to be a member and investor, they will be directed to this document, right? They will be directed to this information. So this should be a part of the due diligence of anyone that's investing in the Tulsa Real Estate Fund. This is something that they should have reviewed and should have had access to. And also the actual operating agreement that is included in the Tulsa Real Estate Fund documents, i.e. the contract, is also filed with the SEC, and that actual operating agreement is in here as well. So we're going to start right at the top here, right? Now, here you have noted what the company is offering. They are offering $1 million in Class A interest. Classes are just different types of investors, right? This is par the course, right? Now you come down to this section here. No public market currently exists for our interest. Wow. So right here on the first page, you already have the Tulsa Real Estate Fund telling you that although they are alleging that they're a publicly traded company, which insinuates that you should be able to buy and sell your interest, you actually can't. So Tulsa Real Estate Fund is not interest or stock in the same way that stock in Amazon is an interest or a stock, right? In the same way that stock in Snapchat is an interest or a stock, because I can buy and sell Snapchat for other stocks. They're telling you right out the gate, no public market exists for our interest. So you already should know, if you're doing your due diligence, like I said, that this is not necessarily an investment, right? So they start by telling you no public market currently exists for our interest. They then tell you the company will be managed by Tulsa Real Estate Founders, LLC, which is managed by J. Morrison, the manager. So you will notice that later on in this document, they will refer to the manager very often, right? So keep in mind that the manager, as is stated here, is J. Morrison. He is the manager, right? The company has set a minimum investment requirement of $500. That means that for you to have any interest in Tulsa Real Estate Fund at all, you have to start at $500. That's the minimum requirement for you to have any interest. Okay. Now they do go on to say subscribers may place as little as $50 into the company's segregated account. So that's a bit confusing, right? Because first you see that there's a minimum requirement of $500, but then you see that you could pay as little as $50. Well, what happens is you could pay $50, and once you accrue the equivalent of the $500, then you become a member, right? So that's how that works. Now, we're going to leave this portion here, and we are going to head on into the operating agreement. So you come down here to the table of contents, right? And you see they have a summary, they have their exemptions, they have a bunch of different things they had to file with the SEC, including what? A summary of their operating agreement. So the operating agreement that all members are given access to had to be filed with the SEC. Let's dive in now and see what the operating agreement says. So here we are. Now we're in the operating agreement of the Tulsa Real Estate Fund. So if you're unfamiliar with an operating agreement is an outline of what will and should and could occur in the operation of any type of corporation or fund or investment. It is considered to be an outline of the rights of the investors, but it is also a warning to the investors, right? Because any risk that you could incur while you're investing is supposed to be disclosed in the operating agreement. The operating agreement will also tell you how much the members are getting paid, right? So if there's a manager like Jay Morrison, the operating agreement should tell you how much that manager receives. The operating agreement should also tell you how much money the fund intends to generate and how much expenses the fund intends to have. I'm telling you all these things as background because as we review this operating agreement, you're going to notice that this agreement does not accurately outline a lot of things about the Tulsa Real Estate Fund that some people might have assumed, right? But you will also see that it outlines a lot of risk that if people were to actually review the operating agreement, they probably would not want to incur, right? So allegedly, this operating agreement has some portions that could be better explained. However, it does clearly outline the risks that are being taken. And that means that either some of the members who are now insinuating they feel defrauded, that they either did not read this operating agreement or that they did not understand this operating agreement. So let's dive in. So it says here, this is a summary of our operating agreement. We have attached as an exhibit the full agreement, and it dives right into profits and losses. So here is the best part. They start out by saying all losses should be allocated in accordance to each member's respective percentage interest in the company. That's par the course, right? It's usual for your interest to equate and your profits to equate to how much you put in as well as your losses, right? That's par the course. They then go on to say that profits will first be allocated pro rata to the members in accordance with the amount of losses previously allocated. Again, just advising you that your interest determines how much your profit is and how much your loss is. Also normal. Now, here is where things get interesting. The very last sentence in this section says, thereafter, profits shall be allocated in accordance with actual distributions of preferred returns. And then profits shall be allocated 50% to the members and 50% to the manager. Pause. Giving a manager 50% of your profits is nowhere near a market norm. So what you will often hear is, you'll hear people say, Jay Morrison doesn't get a salary. Jay Morrison doesn't get paid. But as we read, he's the manager, correct? So management is entitled to 50% of the profits. So think about the implications of the manager and the management not taking on any of the losses, right? The losses are allocated amongst the investors. But then when it comes to profit, 50% of the profit is given to the manager. So it sounds like, allegedly, the manager incurs no risk at all, but splits the profit down the middle with the investors who also have to incur the risk. Again, an interesting prospectus, right? But also I want to highlight that this operating agreement, as I previously stated, is supposed to be read by the investors. Investors are supposed to read this operating agreement. And so if you were to actually read this, then you are agreeing to giving Jay Morrison 50% of your profit. You're outright agreeing to that, and he's telling you what the deal is. Interesting. So now they talk about cash distributions. It's par the course with the profits and losses, with 50% going to the manager. Then they get into voting rights of the members. Now here again, we get very interesting. So for anyone who owns stock in Amazon or Etsy or any of these publicly traded companies, right? You know that every so often you'll get an email that says, hey, because you're a member, we have a vote coming up. Or hey, because you are a stockholder, we have a vote coming up. I recently voted for the board of Amazon and Etsy, right? That's the norm. The voting rights for Tulsa Real Estate Fund don't include that. So here they have noted, the members will have no right to participate in the management of the company. The members will have no right to participate in the management of the company. Wow. So that means that, like how I mentioned with Amazon and Etsy, how I'm participating in the management, I'm voting for internal or external auditors, I'm voting for board members. None of that is included in your quote unquote rights as a member of the Tulsa Real Estate Fund. They then go on to say, members shall have the right to vote only on the following matters. Admission of additional members. Upon the company obtaining capital contributions of $50 million, the manager shall not admit any person as a member, other than as a substituted member, without the consent of the manager and the members holding of all of the interest. So what does that mean? Well, that means that once Tulsa Real Estate Fund has a capital contribution amount of 50 million, then the members that have contributed to that 50 million, then they can decide if additional members can join. You guys, that just means they can decide if they will offer additional shares, if they will offer additional interest. That's it. That's all that means. So that's not some grandiose right to do anything. It's just the right to allow more people to invest. Now here's the second one. Removal for cause. The members, by an affirmative vote of more than 75% of the class interest entitled to vote, shall have the right to remove the manager at any time solely for cause. Remember that term, because that is going to be, I see in the chat that I might have made a mistake and said 50,000. I hope I said 50 million, just as a backtrack. So yes, for cause. Keep that phrase in mind, because that is going to be highly important, okay? So for purposes of the operating agreement, removal of the manager for cause shall mean removal due to the first thing, conviction or civil judgment for gross negligence or fraud. Conviction or civil judgment for willful misconduct or willful breach of this operating agreement. Third, bankruptcy or insolvency of the manager. Or four, a conviction of a financial or corporate felony by Jay Morrison. So here's what all of that means, people. That means that Jay Morrison can only be removed if he gets convicted of a financial crime, if he is found to be liable in a civil court for some type of financial crime, or if he himself undergoes some major financial crisis. That is it. And again, I'm going to explain for those who may not be familiar with investing, that is not the norm. That is not par of the course for a publicly traded offering, right? For an IPO. For a typical IPO, if there is ever a manager that would be better at managing the fund, if the fund has grown to a certain extent, if the corporation has grown to a certain extent, and somehow there is someone who would be better at management, the norm would be for you to politely and diplomatically vote to remove the manager and put in place a better manager. For example, Jeff Bezos choosing to step down from Amazon, right? He wasn't removed, but we all know that secretly, allegedly, he may have been told that he would be removed, right? But that's just an example of how these boards and board memberships typically work. Typically, as the fund grows and as its needs grow, as it expands, then the board will shift and the board will change. So imagine you have Jay Morrison as your manager in perpetuity, right? What if this fund were to grow into the billions? And what if Jay Morrison could no longer handle a fund in the billions? Well, he can't be removed. So this entire section about him only being able to be removed for cause is, first of all, not an industry norm, and second of all, an extremely high standard. It is really tantamount to him not really being able to ever be removed at all. So now you have some sections about limits on managers' liability, which I found to be, in my opinion, par of the course, right? Now we get down to the withdrawal and redemption policy. Again, another interesting section. So this section dictates when someone can withdraw from the Tulsa Real Estate Fund. So when you can say, I want my money back, this isn't working for me, right? Again, I have to remind everybody, Amazon, Etsy, Snapchat, Netflix, you can just sell your stock whenever you want to. You can sell your stock whenever you want to. So notice that you already are looking at something that this is not the norm because they have all these requirements for when you can withdraw. Okay, let's get into it. So they say right here at the top, no member may withdraw within the first 12 months a member's admission to the company. So first, your money has to be in the Tulsa Real Estate Fund for a year, before you are permitted to withdraw it. Again, not the norm for an IPO, you guys. You can buy Amazon stock today, sell it tomorrow. It's literally that simple, and it is usually that simple when you're talking about a publicly traded company. But then it gets even more interesting because then they get into how you can withdraw. And it says here now, in the third paragraph, the company will not establish a reserve from which to fund withdrawals of members' capital accounts, and such withdrawals are subject to the availability of cash in any calendar quarter to make withdrawal distributions. Only after. So the first part of the sentence is telling you that you even being able to withdraw your money is subject to what cash they have on hand, right? And then they set out for you these requirements. So you can get your money back only after all current company expenses have been paid, including compensation to the manager. Oh my goodness, you guys, this is rich. Manager and his affiliates as described in this offering circular. So after Jay Morrison gets paid and after any of Jay Morrison's affiliates get paid, okay? Second, you can get your money back after adequate reserves have been established for anticipated company operating cost and other expenses and advances to protect and preserve the company's investments. So you can get your money back after Tulsa Real Estate Fund has saved enough money to pay up their expenses for however long they decide. And third, you can get your money back after adequate provision has been made for the payment of all monthly cash distributions owing to members. What? So after other members get their return, their distribution, then you can get your money back. So the culmination of these three things, everyone, really equates to the Tulsa Real Estate Fund has a large amount of leverage for deciding if/when an investor can get their money back. They have a lot more leverage than the typical industry IPO. And it really equates to them having so much leverage over when you get your quote unquote withdrawal that it's almost as if they could deny you your withdrawal in perpetuity. And they would always have a reason, right? So we can't give you your withdrawal right now. We don't have the right reserves. We can't give you your withdrawal right now. We haven't been able to do member distributions, right? Et cetera, et cetera. Interesting. So now it goes on to accounting reports and other things of that nature. For our purposes, this is sec.gov, by the way. And I'll probably put the link to this actual document in the chat. But we are going to, for our purposes, move on down to some of the, we have the independent auditors report here. One moment. I wonder if that's all I wanted to review in this particular document. You know what, that might be the gist of, yeah, that's the gist of this document. I now want to take you to another one of their SEC filings. This is it here. Okay, so this is another SEC filing that was filed by the Tulsa Real Estate Fund. Again, for those of you who might be unfamiliar with investing in this kind of fund, members are told before you invest, and also second, while you're an investor, to review these filings. So again, this is part of the agreement. When you sign a contract with these funds, you incorporate by reference all of these filings. So you're pretty much saying, I have reviewed these things, I've done my due diligence, I know my risk, and I am agreeing to it, okay? So this is another SEC filing that was filed by the Tulsa Real Estate Fund. This was filed in 2019, and it's a semi-annual report, right? The previous document we looked at was a prospectus that was filed in 2017. So now what's important in this document is for us to have a conversation about emerging growth companies, right? So here in this section right here, the Tulsa Real Estate Fund refers to themselves as an emerging growth company under Jumpstart Our Business Startups Act, or the Jobs Act. You guys, it's important to make note of that. For those of you who might be unfamiliar with the Jobs Act, it allowed for funds like the Tulsa Real Estate Fund to call themselves IPOs, to call themselves publicly traded, even though they technically do not have the same restrictions and requirements as a publicly traded fund. So going back to my original example, Amazon has to have a board that is public. I have to know who sits on the board of Amazon. That has to be public. Tulsa Real Estate Fund, because they are an IPO under the Jobs Act, they're not required to do that. So again, you may hear Jay Morrison, you may hear other people involved with the fund referring to some type of board, some type of group, but they will never tell you who that is, and they don't have to. So here we go. And this is them admitting that they are a jobs company. So they say that they qualify as an emerging growth company under the Jobs Act. They then say, as a result, we are permitted to and intend to rely on exemptions from certain disclosure requirements. So remember what I just said. The board is just one of the many exemptions. They're going to actually detail for you some more exemptions that they're relying on. So here we go. Here are their exemptions. We will not be required to have an auditor report on our internal controls over financial reporting pursuant to Section 404B of the Sarbanes-Oxley Act. Wow. So there is no auditor that is reporting on the financial moves being made by Jay Morrison. Jay Morrison can make whatever moves he wants to make with the money within the real estate fund, and there is no auditor who is coming in to audit where the money is going and report back to anyone, including the SEC. And the reason that that is not happening is because they're claiming exemption under the Jobs Act. Interesting. Second, comply with any requirement that may be adopted by the Public Company Accounting Oversight Board, remember what I said, regarding mandatory audit firm rotation, or a supplement to the auditor's report providing additional information about the audit and financial statements. Again, the Tulsa Real Estate Fund is not required to have any financial professional come in, look at their finances, create a report, and report to the public what is happening with the money that is being invested. So hypothetically, the management can really do whatever they want. Third, submit certain executive compensation matters to shareholder advisory votes. Wow. So executive compensation is being decided by who? The executives. So can you imagine if you had control of millions of dollars and you were an executive and you get to decide how much money you get paid? You don't have to report to anybody. You're not beholden to anybody. You don't have to ask anyone's opinion. You, as the quote unquote executive, can decide how much you think you should get paid. If it sounds crazy and outrageous, yeah, it might be. I'm not saying it is, allegedly. I'm just saying this is the SEC document and that is not the norm, right? It is totally not the norm for executives to decide on their own compensation. Now here's the last section. Disclose certain executive compensation related items. No, remember that term, compensation related items, such as the correlation between executive compensation and performance and comparisons of the chief executive officer's compensation to median employee compensation. So for example, they don't ever have to disclose how much the manager is getting paid in comparison to how much any employee is getting paid. And why is that important? Well, it's important because of the scale of compensation. So the compensation of a manager of a fund is usually on some sort of sliding scale in which you can see some relation. You can see, okay, so the typical fund managers get paid this, and I see that the on-the-ground investors, the on-the-ground contributors, this is their interest, and this is what employees are getting paid. And there's a scale created there where you see some level of equity. Here, they don't have to disclose that. So again, there doesn't have to be any equity. The management can decide to pay themselves whatever they want. Executives can decide to pay themselves whatever they want. And they don't even have to make it proportionate to what everyone else is getting paid. Okay, so they then go on to say, oh, urban area. I don't know if you guys heard it, but there was a motorcycle. They then go on to say, we will remain an emerging growth company for up to 5 years, or until the earliest of the last day of the first fiscal year in which our total amount of gross revenue exceeds $1 billion. So they are going to be an emerging growth company, as they're saying here, for up to 5 years, or until they hit $1 billion in worth. So the interesting thing about all of these filings is, again, that while they may seem egregious to some people, they are public, and it is stated in the operating agreement that you are disclosing that you've done your due diligence, that you've reviewed the operating agreement, that you've reviewed all these documents. So truth be told, they're not hiding anything from anyone. And that is why when we get into the legal implications here, you'll find that, in my personal opinion, there is not much wiggle room for people to actually have a successful lawsuit, because all of this information is public and they're telling you to go and look at it. And what it sounds to me like is that people are not going to look at these documents. They are not reading these documents. And then later on, they're, in shock and awe, but this information was already there and you were supposed to have reviewed it, right? So those are the two main documents I wanted to review with you. We looked at their initial SEC filing, which included their operating agreement, and then we looked at their 2019 SEC filing. I'm going to now take a quick look at the chat, see if there are any questions that I can answer, and then we're going to talk about, again, a further development of my opinion on whether or not a lawsuit would be successful. But also, let's say you're someone who's already in the midst of a lawsuit, right? What could help you? What could help you? So I'm reviewing the chat. Hi to K Business Podcast. How's it going? Hi, Frat to Pocket Watching with JT. Thank you for letting me borrow your real hashtag, tagline. Let's see who else is here. Hi to Wayne Montgomery. Hi to Orlando Minor. All righty. So I don't think I see any questions in the chat. Let me take another quick look, because if not, we're going to move on. No, I don't see any questions. I see K Business Podcast said, how do you get away with this? Well, the way that you get away with it is you do exactly what the Tulsa Real Estate Fund did, right? You publicly disclose everything. And once it's publicly disclosed, you simply say, hey, I disclosed it. You chose not to read it. I disclosed it. You chose not to look at it. That's not my fault. And that's the truth. So now we're going to get into the legal implications, right? So if someone were to try to sue the Tulsa Real Estate Fund, if an investor, a member were to try to sue the Tulsa Real Estate Fund, in my opinion, they would not have any leg to stand on regarding any type of fraud or any type of misrepresentation. They would have to find something else. There would have to be something else that happened to them personally in their interactions with the fund. Because as we see, there's no fraud going on. When you go and you review these documents are very clearly telling you, hey, there's no public market for this. You can't buy and sell this as you would any other IPO. Hey, you can't withdraw unless you've waited at least 12 months. The manager decides his own compensation. The manager pays himself whatever he likes, right? I mean, we just read the documents together. As ridiculous as some of it may have sounded, allegedly, it's out there. It's public and it's incorporated in you doing your due diligence as an investor, right? So technically, could someone try to sue them? Sure. But do I think they would make it past any initial evidentiary phase? No. Do I think they would be successful? No. But let's say, you gave your last to Tulsa Real Estate Fund. You're already trying to sue them and you're thinking, well, what could I do? Disclaimer, I am not being retained as your attorney, right? So this is just my legal opinion. I think that some of the investors would have to argue that this contract, that this operating agreement is unconscionable. So I'm going to put the word in the chat. It's a legalese word, right? It is the word unconscionable. So what that word means is extremely unfair, extremely egregious, extremely unequal. And so I think some of these investors would have to argue, hey, I am a 35-year-old elementary school teacher. I know nothing about the law. I know nothing about investing. I was scrolling on Instagram and I saw the shade room. I saw this person or that person saying that Tulsa Real Estate Fund was going to empower me. And I just gave them my money. I did not understand in any way what I was getting into. It was unconscionable for me to enter this contract with them because they have all of these egregious terms in there, all of these extremely unfair terms that I was not able to understand because I am unfamiliar with investing. So to break down that argument a level, what you would have to argue is that you could not understand what you were getting into. And that because the terms of this operating agreement are so far from the norm, we discussed Amazon and Etsy. So the argument would be because these terms are so far from what anyone could have expected, and I'm not a lawyer, I'm not a typical investor, I don't know, this is unconscionable and I should be released from this agreement. That is the argument that I think some of these investors could potentially make. That investment could be successful, it could not. I will state, though, that arguments about contracts being unconscionable are difficult arguments to make. They are not very often viewed kindly by the court because the court views the public as someone who has just as much access to information as anyone else, right? So they view it as you should have been able to go to an attorney and have it reviewed. You should have been able to research. You should have been able to look into it the same way that we looked into these SEC filings. I see Wayne is asking, is this a private placement filing 506 or 504? They filed as an IPO under the Jobs Act. So that's their filing. That's their offering. And I think that's what you're referring to, right, Wayne? And I see K Business Podcast asking, so investors can sue? As I said, technically, they could sue, right? Technically, they could. But it is, how successful would they be? And as I said, my personal legal opinion is that it is not very likely for them to be successful. These documents are damning to anyone who tries to sue, because if you just take your time to review them, if you just take your time to read them, you see that this is probably not allegedly the best investment, right? Pocket Watching with JT says, Jay Morrison does a lot of related party transactions. He personally gets loans from the fund at a lower rate than others. His other companies are paid vendors. Can investors sue over that? An amazing question. That's something that I didn't even intend on getting too deep into today, because that's a totally different live, and we can maybe do a live about that. But here is the hard answer to that question, JT. No. Because in the operating agreement, remember that section that we read about operating, and it said the manager has total discretion? There's your answer. The manager has total discretion, i.e. Jay Morrison has total discretion to decide what companies to do business with, what type of business to do, right? And so what that means from a logical and practical perspective is you can't try to hold him to any type of task because he's contracting with himself. You've given him total discretion. You gave him the whole lay of the land. So he can contract with himself. He can contract with his mom, his dad, his wife, his whoever. He has total control. Total control. So I understand that this may be, as I said, a harsh truth for some who have invested in the Tulsa Real Estate Fund, but I think there's a lesson to be learned here, and it is two things. First, SEC.gov is your friend. And second, operating agreements are something that you should review. Before you can become a member of Tulsa Real Estate Fund, they give you a whole slew of documents, right, that you agree to and you sign. You have to actually review documents when you are investing, especially when you're investing in something that is not, as I like to say, par the course. So it's not a Netflix or a Disney or an Amazon, right? Or a Con Edison or something of that nature. It's an off the beaten path investment. Whenever you are investing in something that is not the norm, you have to do your due diligence, and the law will expect that you have done your due diligence. As I said, with some of these investors who may want to sue, the law is going to expect that they did some level of research before they just handed over their money. And I think that is the dangerous thing that might be happening, is that people are just handing over their money without doing any research. So we've been on for about 43 minutes. I'm going to take a look here. Wayne Montgomery has another great question. He said, can the states individually block their offerings in individual states? No. So as you know, the Jobs Act is federal. IPOs are available really on an international scale, right? Depending on what platform you have access to. And it's not something that states have control over. I don't see any other questions. No, alrighty. So does anyone else have any other questions or concerns or anything else you'd like to know about this? Let me copy and paste these documents, the link to these documents, as I said I would, because I want all of you to have access to them in case you know someone that it might be useful, right? So I believe that is the initial agreement, right? Now I'm going to copy and paste the next one. All righty, copy and paste. All righty, so here we go. You have the link to the SEC documents, right? You can take a look at them. You can share them with someone who you know either has invested in Tulsa Real Estate Fund or might be interested in investing in Tulsa Real Estate Fund. So you can have a conversation with them about what they're getting into so they know. And again, I am not saying that you should or should not invest in Tref, right? What I'm saying is you have the right to do with your money whatever you like, but I am imploring you to do it in an educated way. That's all I'm saying. Invest in whatever you like. Invest in your local ice cream man if you want to support local business, right? But do it with due diligence, my people. Read all your information. Read your operating agreement that binds you as an investor. Do it with due diligence. That's all I'm saying. Okay. So if we don't have any more questions, I'm not going to make this stream extremely long because I'd like for people who want to view it later to be able to hop on in and join the replay, right? I am, oh, hi, Crime Spotter. Check out the replay. We went through all the SEC documents and we went through the Tulsa Real Estate Fund operating agreement, okay? So I'm going to go ahead and hop out of here. I am Phylicia D.C. Pearson. I am a practicing attorney from Above the Bar Law Firm. You can check us out at weareabovethebar.com. I'm putting it in the chats. And of course, you're here at my YouTube channel, so you know this exists, right? We're rolling. We do one video a week. We will do some live streams from now and again. We may talk about Jay Morrison again, but what I have next on my my schedule is to look into the Umar Johnson federal lawsuit. I'd like us to talk about that in our next time, right? I want to start digging into some of the legal issues that are going on in our community, if you will. All right, so it has been great spending time with all of you, and I will see you next time here on Empowered Esquire TV. Thanks for the new sub.